We've noted that there's no federally mandated security standards several places in the unit to date. But the FTC has stepped up to fill this void using Section 5 of the FTC Act. But with the LabMD case still at issue, the future of FTC enforcement actions may be at risk. 47 states and the District of Columbia have individual mandates for breach notifications. These require companies and government agencies upon breaches to report to consumers, regulators, and credit bureaus. These laws are very important to your security strategy because you have to understand how those state laws will impact you should you have a breach. You need to understand a number of different things if a breach occurs. For instance, if a burglary takes place in one of your offices in California, computers are stolen, the office informs you that sensitive data was stored on them. What type of data was stored on the computer? How many records were stolen? Did all of the data pertain to just California residents, or were users in other states impacted? And what are your disclosure requirements? You have to understand all of these elements if a breach occurs, and you have to understand them fairly quickly. Knowing what to do and what to ask ahead of time is very important. Keep in mind that you don't have to have servers or employees in a state for the state law to apply. It's all about the data. If it pertains to a user in a particular state, that state's laws apply. The relevant state laws will determine whether and how a company must disclose information about a breach. How must you provide notice of the breach, and how must you inform the credit bureaus, regulators, and the consumers? Keep in mind that the state laws in many cases look very similar, but there may be important differences, and it's important that you understand those differences. Some of them may differ in how they define sensitive personal data, and the states may differ in when regulators may need to be informed. Very important consideration is that companies have contravening goals that they have to accomplish. On one hand, you're required to disclose the breach within time frames established under the state data breach laws. On the other hand, you have to understand the breach. What's the extent, the type of data compromised, and even if any sensitive data was compromised. And you have to manage the delays imposed by law enforcement. Inaccurate disclosure can subject a company to additional penalties under the state regulators. Data breaches may not require disclosure, however. If the data are encrypted, in every state except Tennessee, no disclosure is required if the decryption key was not available. Important to understand any exceptions available under the prevailing state laws, because those exceptions may apply to the case that you have before you. Then even if you don't have sensitive data, will a company choose to notify consumers anyway? Well, it may be. Are the breach notifications good business if no personal data were compromised? Is transparency a fundamental principle of the company? Well, those are questions you have to ask. Even if notification only has to occur in one state, the news will make its way to the internet and to journalists. State data breach laws only apply to unauthorized acquisition of personal data. This is defined by each state's data breach laws, however. So if the compromised data doesn't meet the definition of personal information, then a company doesn't have to disclose the compromise. However, in every state there are minimum amounts of data that have to be reported if you have to disclose a breach. In almost every case, it's first name or first initial and last name, and at least one other category of data, such as a social security number, a driver's license or state identification number, the account number, such as a credit card number, a bank account number, or debit card number, and any passwords or any codes that are necessary to get into the account. Medical information, health insurance information, and you could see these: online account information, biometric data, taxpayer identification numbers, tribal identification numbers, any federal or state identification number, and date of birth. The mother's maiden name, employment identification number, passport number, digital signature, and even in the state of California, the zip code of an individual. California and Florida require notification even if the consumer's name was not compromised. So instead of first name or initial and last name, could be username or an email address and a password or a security question that is necessary to use that account. As I said, Tennessee is the only state that doesn't provide an exception for encrypted data. An issue might be the technical specifications for encryption, however. For instance, Massachusetts requires 128-bit encryption, and the other states don't specify. It's important that most states require the decryption key not be accessed. So two issues face the security people in the course of a breach. Can we prove that the encryption we were using is sufficient to protect the data? And can we prove that the decryption key was not accessed? Another issue that faces or could face security personnel is if you're subject to PCI DSS and credit card data is impacted, the decryption key cannot be anywhere on your network. Now, for those of you who work with encrypted data, that poses some very interesting problems in being able to process your data. The risk of harm is a very interesting concept. In 38 states, notification can be avoided if it can be determined that there is no risk of harm for individuals. In Tennessee, for instance, this is the only exception to the encryption rule. But each state varies in their concept of risk of harm. This goes back to understanding how each state's data breach laws might impact your security operation. In Michigan, for instance, a security breach is not likely to cause substantial loss or injury or identity theft. So that would be the scale for risk of harm. In New York, does not compromise security, confidentiality, or integrity. That's a fairly broad statement on on how to protect data. Most state notification laws require companies to notify customers as expediently as possible, without unreasonable delay, and the wording varies by state. So you have to understand how those notification laws, again, will impact your operation if there is a breach. Even without clearly defined timing, state regulators will not tolerate unreasonable delays. 8 states actually provide a specific time period. Florida within 30 days, Ohio, Rhode Island, Tennessee, Washington, Wisconsin, and Vermont within 45 days, and Connecticut 90 days. All states allow other companies to delay notification if the delay would harm a law enforcement investigation. The form of notice that this notification has to take is defined by each of the states. So you must deliver notice in the medium that's approved by the state law for where that data is from. So all states allow written notification to the last known address of an individual. Most also allow email to the last known email address. Some states only allow email notification if email was the primary method of communications. And about half of the states allow notification by telephone and a handful by fax machine. There is a concept of substitute notice also, because in most cases you don't know either the last known address or the email address of a compromised individual. So a substitute notice is used when you don't have that sufficient contact information. If the total cost of notification would exceed the amount specified by the statute, or the company would be required to notify more than a specified number of people. So in some places they may say, the state law may say, if there's over 500 impacted records, you have to use you can use a substitute notice. This generally consists of three elements: the email notice to any individuals for whom the company has an email address. If the company has a website, you can use a conspicuous notice on about the breach on your website, or you can notify a major statewide media. So occasionally you'll see these notifications in the ads in the newspaper from various big cities. Most states do not require breach notice to contain specific information, however. But a minority of those states require very specific statements about the data. The contact information for the company, general description of the breach, categories of personal information compromised, the dates of the breach, contact information for major credit bureaus, the state attorney, and the FTC, and advice to remain vigilant about identity theft by reviewing your credit reports, and information about identity theft protection systems. And even if you're reporting to a state that doesn't have specific information designated, these are the elements that you would want to put in that notification. 31 states also take reasonable steps to dispose of records that contain personal information, such as shredding paper records, rendering personal information unreadable or undecipherable, preventing the information from being reconstituted. So again, we talked about if you have disk drives, you want to wipe the data on the disk drives. You want to shred paper or burn it, or put it into a liquid and have it dissolve. But you want to make sure that data is rendered unreadable. Most state statutes do not define what reasonable measures meet the letter of state disposal laws. There are a lot of third-party companies that can be used to dispose of records, but you want to validate the operational controls of that third party. You want to get references and review the security practices and policies to ensure that they securely handle any of the records that they're destroying and that they are actually destroyed. In many cases, you can also ask for a certification that they have destroyed the data. So final thoughts for Unit 1. We've had lots of things to consider with respect to the legal foundations around collecting and protecting sensitive personal information. We looked at the FTC and use of Section 5 of the FTC Act and how the FTC has assumed authority to enforce data security through its enforcement actions. We also looked at how the various states have implemented data breach laws governing companies' actions should they be breached. All of this information is important for the leaders of a security operation. When I was the chief security officer at a company, all of this information were things that we constantly looked at, particularly as state laws changed, so that we would understand how the change in a state law would impact our operation. If a breach occurs, it is the worst time to start planning on how to respond. Incident response and interaction with a legal group must be determined long before it is needed.